Make sure I have record. All right, recording started. All right. So welcome everyone to today's webinar. Thank you so much for joining for the Ocean Rights and an Emerging Movement. I am Michelle Bender, the Ocean Rights Manager at the Earth Law Center. I have been working for the past 3 years on developing a new legal framework for ocean governance, which incorporates the rights of nature approach into marine protected areas. I also serve on the executive committee for the Global Alliance of the Rights of Nature, which is a global network of organizations and individuals worldwide working together to advance this new paradigm for humans and nature. Today, we also have Barbara Laschi, who is the director of the Marine Policy Institute at Mote Marine Laboratory and Aquarium. She also has served on both the IUCN's World Commission on Environmental Law and Protected Areas and contributing to many IUCN publications, also advising on law and policy principles for biodiversity conservation and connectivity conservation for the ocean. Last but not least, we also have Jacqueline Evans, the director of the Marae Moana Coordination Office at the Cook Islands Office of the Prime Minister. She has a longstanding commitment to ocean conservation in the Cook Islands and recently won the Goldman Environmental Prize for islands and island nations for her work to establish the Marae Moana, the Cook Islands Marine Park over the entire Cook Islands ocean territory. This webinar is part of a whole series in partnership with the Ecological Law and Governance Association, the IUCN's World Commission on Environmental Law, Center for Environmental Ethics and Law, Earth Law Center, the Australian Earth Law Alliance, and Economics for the Anthropocene. It's an annual series of courses created by experts, practitioners, and academics in ecological law and governance. And I will include the link to the webinar series in the chat box where we can also, or you can also have access to previous webinar recordings and see upcoming information as well. I ask that we all keep ourselves muted and save questions until the end after Jackie. We'll have plenty of time for questions, but throughout, feel free to input comments into the chat box. So if you don't want to lose track of the questions you have. And we would also love to know who all is joining us. If you haven't already sent an email with registration, please feel free to put your email and information in the chat box throughout as well. And so this webinar is incredibly timely. We are seeing great progress and momentum around ocean conservation right now, including the upcoming treaty negotiations at the United Nations for protecting biodiversity on the high seas. But it is also necessary to share our experiences due to the IUCN support and mandates that call upon us to adopt an evolved and holistic approach to ocean conservation. Since 2011, the IUCN has passed resolutions and published guidelines and reports that call upon us to incorporate and commit to the inclusion of rights of nature. The problem is we're calling upon such a shift, but progress has been slow to implement, in part because we need more opportunities to share information and lessons learned. And so this is where this webinar comes in. We'll start with Barbara, who will highlight the evolution of legal principles and guidelines for marine protected areas, the successes, the challenges with current frameworks. Then I will go on to introduce ocean rights and the Earth Law framework for marine protected areas, the guideline for evolving our current framework to include the rights of nature, and which leads to Jackie, who will walk us through the development of the Marae Moana Sanctuary, which really exemplifies the commitment towards ocean rights and the evolution towards an ocean-centric worldview. So again, I ask everyone to please stay muted throughout, and feel free to put questions in the chat box. And from here, I'll turn it over to Barbara to kick things off. So I just need to stop sharing my screen and then hear yours. There we go.
Very good. Welcome. I'm Barbara Lauschie, and I've worked on these issues for quite some time. I'm so happy that Michelle and the Earth Center have been able to organize this, and I really appreciate all the participants that are interesting. I don't want to dwell on this, but my baseline is MPAs are essential for ocean health and biodiversity conservation. MPAs need supportive legal frameworks, and we have a lot of work to do yet because many laws are outdated. They're not reflecting the latest science, best management practices, connectivity, planning needs. Before we begin, some context. I just wanted to emphasize how beautiful this planet is from these satellite photos. Of course, 4.5 billion years old, with the ocean about 4 billion years old. So it is in charge of the planet. And I'm including this little Antarctica map here to show you that this is the one place on the planet where all the oceans link. So some scientists will call the oceans only the ocean, but this means that life is interconnected, that organisms can move from one to the other, and impacts can also move. Why does the ocean matter? Those of you who work with marine issues probably already know these statistics, or if you've been in IUCN meetings, but almost 3/4 of the planet is ocean. 97% of the world's water is from the ocean. It generates more than 50% of the Earth's oxygen. So take 2 breaths. One of those is coming from the ocean. More than 90% of the planet biologically useful habitat is in the ocean. Ecosystems that it performs for services are critical to life, and according to the Millennium Environmental Assessment of 2005, it's among the most threatened. Of course, it is driving climate and weather. It absorbs much of the CO2, and it also produces fresh water through the formation of clouds. We know it supplies food, which is a big motivation for industry, and it contributes billions to the national economy. Why so many challenges? The characteristics are the key. The ocean has special features inherently different from terrestrial systems, and when you come to look at law and policy, these get triggered. If we don't understand the science of these, it's very difficult to know how to handle the legal framework, the objectives, the regulations. So you can read all of these, the 3-dimensional space, big connectivity issues, the exclusive economic zone, which for some countries is larger than their land area, and depths down to 11,000 meters, which means that the depth of the water is deeper than the highest mountains on the land. Threats are commonly known: habitat destruction, unsustainable fishing, land-based pollution, and now climate change. Pretty much in the literature, you're going to see climate change is being identified by marine scientists as the #1 long-term threat to the ocean. We've got these various impacts of climate change that we have to deal with. as a result, our management challenges, in addition to the characteristics, become even more difficult with climate change. But we have a difficult research environment, special equipment is needed, different kinds of property rights and diverse stakeholders, and then there's truly less conservation awareness among the public that these are important threats that the ocean needs to have ways to reach better management and conservation. This is a schematic. The ocean floor, creatures on the floor are called benthic creatures. Creatures in the water that swim and migrate are called pelagic. This just quickly shows you the difference in depths and an appreciation, but very basic so far, about what the deep ocean contains. This is a schematic that came out of the first census of ocean life in 2010, and I'll mention that briefly later. So here we have rich biodiversity sites and vulnerable sites, deep ocean sea corals, deep trenches, the nodules, some call them manganese nodules, cold seeps, mud volcanoes, hydrothermal vents, and seamounts. And you can look at this more at your leisure. So now let's begin. I will cover, hopefully briefly, and but with understanding, the basics of modern MPA law, basics of what's going on with marine connectivity in law, marine spatial planning, an emerging new area for law and science, other supportive tools, and key challenges. I don't want to get into this, but we have an ocean that's 4 billion years old, and we have many, many thousands of years where there was just the ocean functioning. We didn't have our first navigation on the surface till 4000 BC. That allowed the collection of surface data. But I wanted to emphasize here that our first scientific expedition was not until 1872. That's the year Yellowstone was declared as a land national park. And we were just having our first scientific expedition over 4 years. Then the first ocean vessel, research vessel, Atlantis, then CSAT, the first satellite focused on ocean studies. Then satellites start booming, and we have NOAA's Explorer launched in 2010, and China's submersible, which, so far as I can find out, now goes deeper than any human carrying device of that time. And these are current pictures. The evolution of marine protected areas purpose then was followed by evolution of law. So you have historical use of the ocean and marine protected areas basically to manage fish breeding areas, to protect the fishery. And so frequently they were called fish areas or marine reserves or sort of conservation management areas. Then you had also cultural and sacred sites. Since the 80s and 90s, as science has improved, our goals have shifted in purpose and in law to biodiversity conservation, ecosystem-based management, ecological principles. So now we are here where we're looking at area-based management and we're working with best available science. This brings me to the publications that IUCN has been part of and that I've helped with basically since 2011. We have the guidelines for protected areas law. We have legal aspects of connectivity conservation and integrated planning. All of them have separate chapters on marine. These were gradually translated into curriculum seminar series with exercises and lessons and videos, and you can find those today at that website. The international law framework usually is the one we start with, just to highlight these 7 conventions, 2 of the ocean, and then by implication and by application, conservation treaties that are really having a big impact on how countries manage, especially conservation within national waters out to the 200-mile exclusive economic zone. One of the contributing pieces of guidance from the CBD actually calls for using consistency and scientific criteria and guidance between MPAs that are in national waters and MPAs that are in areas outside of the national jurisdiction, the high seas. You can see these, they're all quite modern. They're all the kinds of things that we would, as lawyers now, put into modern marine protected areas, legal instruments to guide selection and management. Helping to push modern day efforts to expand our marine protected areas are especially 2 targets. The CBD target under the convention, target 11. By 2020, they aimed for 10% of coastal marine areas under protection. We're now at 7, so it's been a massive increase. By 2030, the World Commission on World Congress Conservation of IUCN upped that to 30%. And then we have the initiative of E.O. Wilson, the distinguished professor at Harvard, trying to protect half Earth by 2100. We have definitions that are established definitions that we will work with in the legal frameworks. MPA is pretty clearly defined, and you probably have already seen that in many places. The primary goal of all the categories of MPAs in IUCN 1 through 6 is biodiversity conservation. When we move to networks, we're talking about collection of individual MPAs, again, with the range of features and levels of protection that could apply between categories 1 and 6. Other effective area-based conservation measures is brand new. It's out for review. This is what the definition is right now. It's not a protected area, but it's an area that contributes to in situ conservation of biodiversity. It's very important, and it probably will be used to achieve some of the targets under the CBD. Then there's marine connectivity, equally new. We're just working on this, and we have a draft out for review now in the Marine Connectivity Specialist Working Group of the WCPA. It's the corridor idea that we're applying with ecological connectivity as the concept. Substantive areas of MPA law, all are interrelated. In MPA principal legislation, we usually have a planning section, establishment, management, and governance. You can see these various elements that are in the guidelines, and you can also see that, particularly for governance, which is a relatively new area, we're not only talking about decision making, but we're talking about opening up diverse governance types. In the marine protected area world, 2 non-state actors. Then we have the tools for implementation, regulation, promoting compliance, which is largely with education and involving local peoples in implementation, and then enforcement and surveillance. Here, the special challenges of the sea really hit us, and we do need special tools increasingly to monitor, observe, and note effectiveness or change. One of the case studies that we did for the PA guidelines was to have the protected areas manager for the Gully Marine Protected Area, a deep water protected area in Canada, write his case And the basic message here was they're doing almost everything in monitoring and enforcement through remote sensing. If ships come by, they have to have onboard transmitters by the rules of the International Maritime Organization. Those signals, if they get too close around the buffer zone, those signals end up being transmitted to the National Park office. They send out a helicopter and they check the ship and they warn them and they get them off. Then another useful tool that we need to have with marine is looking at boundaries. So the recommendation of scientists is try to always have straight and simple boundaries. This not only helps when you're doing monitoring from satellites, but also when you have ships in the area. Okay, second area, marine connectivity. We have this document, came out in 2013, relatively new area for science and an even newer area for law, because now we're working with planning in larger spatial scales. This is a little bit of an illustration of what connectivity is in the ocean. It's currents and marine life moving through, and marine life in sometimes different stages of the marine life, following currents or following important destination points. What is connectivity? It can happen between populations, between sites, and of course, there are a lot of complexities in terms of linkages, the time scale and the spatial scale. We know so much less about marine connectivity than we do about terrestrial systems. How does it happen? I just am giving you 3 examples here. This is sea turtles that we tag and track. Some of these sea turtles circumnavigate. It's beautiful to see. Then we have, in a smaller scale, larval dispersal. And usually if it's going to go out and be effective, it's going to go to another coral reef or another very nearby habitat. And then you have coral reefs, which are an important habitat for connectivity for the early years of life, the life cycle for marine life. And here is something we targeted in the shark department at Moult, because we tag these guys. This is one of our Moult guys. Tag whale sharks and follow their signals. And this whale shark, called Rio, because she ended up in Rio, off of Rio, had this pattern for several years. Okay, tools for connectivity. I'm not going to go through these. You can do this, but there's large marine ecosystems, a program that's been going on since the 70s. Marine spatial planning, which is coming in many countries now. Typically, it's a plan, but not a mandatory, legally binding plan. Aiming to look at competing uses and find some rationale for keeping the conservation resources valid and also the economic opportunities there. Then you have ocean zoning, where you go to regulation. They use the maps normally of marine spatial planning, and then coastal zone management, which is an old timer from the 70s, working with planning schemes that really focus on the near coast waters and the coastal zone on the land. Marine spatial planning, supporting tools for MPAs here. This is really important from the bigger macro perspective, where some programs say from the ridge to the reef, and various governments have funded these things, or from the ridge, especially in the Pacific, where they're working on things now. This is sort of an illustration of why we need to think about marine spatial planning. In principles, this is a planning framework that very few countries so far are able to achieve. It's integration across sectors, longer-term planning horizon, mainstreaming climate change, of course, using the best available science, coordination across all the interests, including private interests, mapping, prioritizing, and especially finding the right measures for compliance and enforcement, because the ocean is such a special region for large-scale planning. Other supportive tools I just wanted to mention, IUCN has a new Protect Planet Ocean initiative, and these are very impressive co-founders. We have the first ever, I mentioned it briefly before, Census of Marine Life in 2010. Curiously, the first ever. This is just amazing to me. And it took 10 years with about 2,700 scientists and more than 500 expeditions, 30 million records. And this will be baseline now for research going forward on how marine life is dealing with such change as climate and pollution and other factors that are major threats. Another new initiative, Healing Our Oceans. You can go to this website and click on some of these different colors. There is an index in the website, and get a sense of the health of that marine near coastal zone. It's evolving, but this is happening every year now. They've got it organized, and it's all on the internet. Then we have all these remote sensing tools that I won't get into, but it just highlights for me how fast we are moving with new technology and how important it is that this technology continue to advance as we begin to truly appreciate the value of the ocean for all of us. Key challenges, of course, the immediate need, we need to, from my perspective, we need to get our laws in order, and we need to implement these. A recent study found that more than 40% of the MPAs are largely paper parks. Competing objectives, issues of political will, excuses of lack of capacity, all these things are causing other priorities to outweigh conservation. We need to build local capacity to use science. We need to strengthen the institutions to have the government as a whole approach ocean conservation and management. We need to take into full account the activities of the non-state sector, indigenous peoples, their rights, the private sector licenses, the NGOs who may have very good expertise in helping manage. We need to deal with the vast water column and deep waters of the ocean, which in most MPAs isn't covered. You have to go to the deep water. In some cases, it's now being covered, but we know very little about it. We need to deal with connectivity. We need to deal with climate change, and we need to work harder to build safeguards and systems to ensure accountability of the decision makers, to make sure they implement the laws as we would hope they would be properly modernized. This is your reference page, which you can see later. And I wanted to conclude with this. This is our goal going forward for sustainable development, and it is focused on overall ocean health, healthy coastal and ocean ecosystems and marine life, management strategies using an ecosystem approach, ocean policy based on ecological objectives. This, from my point of view, leads us right into the issue of ocean rights. So let me thank you for listening, and I leave you with that quote, and we can move to you, Michelle.
Thank you, Barbara. Thank you so much for the great presentation and the kickoff to our webinar. I just want to note that Jeff from ELGA has put a Google Docs sign-up sheet in the chat. So if you're able to access that and sign in on that, that would be great. And then I will go ahead and share my screen. right, there we go. All right, so I will be shifting gears quite a bit towards rights of nature, or ocean rights as I like to call it, looking at how it can further ocean conservation efforts with some lessons we've learned in the movement and examples of what it can do. And I want to start by taking a different look at some of these gaps in ocean governance that we're seeing. In my opinion, we're still approaching protection and management, like Barbara noted, from an anthropocentric view that allows human interests to outweigh conservation objectives. And as a result, we're allowing destructive activities in protected areas, which is contrary to their purpose. A large reason why this is allowed is due to the underlying values and language guiding our laws and policies. We can take a look at fisheries. The Food and Agriculture Organization defines about 90% worldwide as either fully exploited or depleted. One reason this could be is under business as usual practices, we tend to focus on this term maximum sustainable yield, or the maximum we can take out of the system. And in most cases, humans are not considered as predators within the system, and we set limits much higher than science recommends due to a focus on profit. Additionally, we equate the ocean and its species to a resource and a commons as objects and property. And this reinforces the idea that humans are separate from nature. So how can we ensure that our laws reverse the trends in environmental degradation rather than merely manage the decline? And many are turning to rights of nature or earth law as a solution. The rights of nature framework recognizes and protects in law nature's inherent rights. Just as humans have rights for being and existing, so too do the ecosystems and the species with whom we have co-evolved. By recognizing rights of nature, we are required to shift our behaviors and shift from treating nature as an object that we own towards a fellow Earth community member that we have responsibilities towards. So in practice, it legally requires us to shift our decision-making from an anthropocentric point of view and from making decisions based on the wants and needs of humans in the short term towards an Earth-centric point of view, towards decisions that have a long-term vision. And momentum is growing. We're seeing rights of nature laws now emerging in over 20 countries. Essentially, we're seeing two approaches in this movement. On one hand, countries and cities are passing laws that recognize nature as a whole has rights, and it gives the communities the rights to speak on their behalf. This is the case in Ecuador, Bolivia, Mexico City, and actually over 24 municipalities in the US, including Santa Monica. And on the other hand, we're seeing entire ecosystems being declared as legal entities or as a legal entity subject of rights. And in these cases, guardians are then created to represent the ecosystem's interests in decisions and disputes. And this is what we're seeing in New Zealand with the Whanganui River, the national park and a mountain, as well as in Colombia and India through court decisions. And I also want to be really transparent that rights of nature is not a solve-all solution. It's just one tool being utilized to correct our anthropocentric legal frameworks. One misconception that we have when we first hear about rights of nature is that it's all about rights. But really, at the core, rights of nature is this ethics and philosophy that matters, not really rights per se. With rights, you also have duties and responsibilities. So rights is a means to recognizing and adhering to our responsibilities towards the earth to leave it no worse off than how we received it. We're also finding internationally that even when rights of nature is codified in law, it's still proving hard and challenging to implement and to transition to a sustainable society, especially in places like Ecuador and Bolivia, where their economies are largely dependent on extractive industries, fossil fuels. Traditional cost-benefit analysis is really hard to overcome in these cases. And A last challenge is seeing and knowing when and how nature's rights are being violated. So, for example, in Bolivia, their national law actually defines some of these rights. So the right to clean air, the right to clean water. But the problem is that we don't really identify what is clean. And so that's being largely left up to interpretation, and it's being defined largely judicially. So after damage to an ecosystem has already been done. Now, going back to the IUCN's mandates calling for a rights-based approach, it became clear that we need help navigating how to do so, how to approach ocean governance from a rights-based approach. And so I began to look at how we can evolve current protection frameworks like MPAs to ensure holistic management that respects the rights of nature. And this led to the development of the Earth Law Framework, which was created after months of research, writing, global input from experts, and it really serves as this foundation and guideline for how to start. And in developing it, I focused most on standards and criteria, because we're finding it's not enough to say nature has rights and what those rights are. We really need a threshold for when nature's rights are being violated or when ecosystem functioning is becoming compromised. We need these thresholds regarding the key areas for regulation, including fishing and tourism. And for the three types that Barbara mentioned, prohibitions, general rules, and permissions that make it into the framework for MPA's management. And the framework begins to develop these standards, and I group them into three broad categories: economic, governance, and biological. Let's take economic criteria. We traditionally look at the cost to humans in the short term when we're weighing a decision. An evolved rights-based approach requires that now when weighing decisions, we take into account the true cost of an activity and its impacts throughout its life cycles. So we look at externalities and the cost of extraction or exploitation, not only on the immediate environment, but also after its use, after the activity is already completed. An example of this type of standard can be found in Ecuador. In a recent illegal fishing case, a valuation study was performed that showed that the benefits of a live shark throughout its lifetime provided up to $5 million in benefits. And on the contrary, showing that cutting off the fins, selling the fins on the market only provides $250. And so this helps us see how using this type of standard helps us to properly decide what we're going to allow, what we're going to prohibit, if shark fishing should be allowed. And this is exactly what they've done in the Galapagos Marine Reserve. Second, traditionally, good governance includes that protected areas are managed in an open, fair, transparent way. They're inclusive. The IUCN has some really good guidelines on what is good governance and how to achieve that, especially with their new green list that they're working on or already have established. But good governance also includes governing these areas for their benefit. So to have conservation as the highest objective. Standards can help ensure this. For example, we can develop a scoring system, something like what the Marine Conservation Institute and GLORIS program are working on, where they have weighted scores for the type of gear or activities. And for example, you can give a lower weighted score for the most destructive activities or gear like gill nets and purseine fishing. And you can give the highest scores for the least destructive gear or activity. Something like seasonal closures would have a higher score than allowing fishing all year round. And this really encourages us to choose the least destructive option when evaluating alternatives as we're going about deciding what level of activity we're allowing in marine protected areas. And finally, it's important to use the best available science. as we develop these standards through biological criteria. For example, keystone species like cetaceans, sea otters, and corals, they serve as indicators of overall ecosystem health, and they can help us further regulate or prohibit an activity. If these species are declining, they're not doing so well, it's a sign that the ecosystem is not healthy and that disturbances are present. We can take the example of the southern resident orca here in the Salish Sea, whose decline has also showed us that the overall ecosystem is not healthy. Their principal prey source, the Chinook salmon, are also endangered. PCBs and PDBEs, pollutants, contaminants are high in concentration in the waters. And we've also seen a big increase in vessel traffic throughout the area. And we can see by looking at this graphic that if we look at vessel traffic and how foraging behavior is affected, we can make policy decisions to regulate vessel traffic at levels below a threshold that affects the orca's foraging natural behavior. And this will not only help to provide minimal disturbance to the orcas, but also the ecosystem as a whole. And we have been working at multiple levels and multiple ways here at the Earth Law Center to launch new initiatives to implement this new framework. And each are developing, different pathways that are available. One option that I noted was just focusing on rights for nature as a whole. Another, looking at legal personhood for an ecosystem, so designating a marine protected area as a legal entity. And alongside with that comes management that includes guardianship. And we can utilize all these components. We can decide to just focus on one. And so our initiatives range from the local level to the international. For example, we're working with local communities here in the Salish Sea area to not only recognize that the orcas have inherent rights, but their broader ecosystem does as well. We're working with partners in Uruguay, the Organization for the Conservation of Cetaceans, to pass new law that recognizes that the whale and dolphin sanctuary is a legal entity subject of rights. And then Jackie will go a little bit more into this initiative, but we're also working with Pacific Island partners on creating a new convention that recognizes the Pacific Ocean as a legal entity and recognizes the Pacific Islanders' kinship with the ocean as well. And of course, because most of the ocean is considered in areas beyond national jurisdiction, we also need to work at the international level. And so we, for example, have supported including rights of nature into the IUCN's 2017-2020 action program that was developed at the last IUCN Congress. And then we're also exploring what it would look like for the high seas to have legal rights and to be taken out of the realm of property as well. And now I have two examples that highlight how this rights-based approach to MPAs can look like in practice. And the first is Ecuador. In Ecuador, the rights of nature was put into the Constitution in 2008, and it's foundational to the management of protected areas there. A great example, the Galapagos Marine Reserve. It's managed what is called the special regime or the special law of the Galapagos. In this law, there's a guiding principle that we should strive to achieve equilibrium among society, the economy, and nature, and that we are to respect the rights of nature in our management and governance of the area. As a result, the Galapagos has pretty high standards in place. Rights of nature has helped to ensure that there's no industrial fishing, no shark finning, and actually harming sharks is a criminal offense. Economic activities are limited to permanent local residents of the island, which is only 27,000 people. And tourism levels, for example, are determined using environmental impact studies. So they limit how many boats will travel from one island to the other, looking at the environmental impact. And there have been 3 cases involving sharks in the Galapagos Marine Reserve, and another involving mangroves in Ecuador, all have ruled in favor of nature, noting that nature has rights and it is Ecuador's responsibility to guarantee those rights. And finally, laws have been passed as a result of rights of nature in Ecuador. You can invoke the constitutional amendment in order to pass new regulations, such as the prohibitions on certain types of fishing gear. So Ecuador really shows how rights of nature can provide for effective and enforced marine protected areas. And the second example I have for you is in New Zealand. We have an example of guardianship, human representation of the ecosystem's interests. New Zealand created the Hauraki Marine Gulf Park in year 2000, and it has what is called the Sea Change Marine Spatial Plan that goes along with its management. And this plan actually calls on communities to think of the environment as a being in its own rights. And so this is a great example of what our goal is with rights. It creates a guardianship system with the local iwi communities, giving them the judgment over issuing permits for extraction and human activity. It also calls for guardianship to be practiced by all and every person to be given opportunities to participate. So you and I could become involved in decision-making, monitoring programs, and restoration projects if we live there. And the main objective of their customary environmental law is actually to maintain a proper balance between people, land, and sea. So they really take into account the land-sea connection, which is so critical. And in practice, they set temporary restrictions on fishing in certain areas. They really pride themselves on harvesting only what is needed. In the Marine Spatial Plan, it also establishes a network of co-managed MPAs with a nested approach in which areas of no take, so where no extraction, no activity is allowed, these areas are nested within larger areas that have fewer restrictions. And so as I wrap up my part of the webinar, I want to bring it back to the purpose of MPAs and the IUCN's guidelines for them, which are listed here. We see that MPAs are to have the highest objective of conservation, to eliminate exploitation, and to increase or maintain the degree of naturalness. But this is proving hard in an anthropocentric legal system that allows human interests to outweigh conservation. Rights of nature or ocean rights is one way we can really ensure that these objectives are met. Rights of nature shifts the paradigm to an ocean-centric management with humans within the system. As a result, we completely change the game. We alter how decisions are made. Now decisions ensure a balance with human activity and ocean health. And now I will turn it over to Jackie with the Marae Moana, because this sanctuary, in my opinion, it really exemplifies where we need to go and what rights of nature or ocean rights, the philosophy behind it can really give us. There we go.
Hi.
Hi, Jackie.
Yeah, hi. I just had to run out the office to ask the cleaner to turn off the vacuum cleaner.
Perfect timing.
So yeah, I'll just get this started. So let me just put my PowerPoint presentation up. Okay. So I'm going to be talking about the Cook Islands, just a little bit of background for those of you who don't know much about this country, and how the Marae Moana was conceived and the process to establish it, and the main points of the Marae Moana legislation. So this map shows areas of land indicated in yellow. So The other colours are our exclusive economic zones, and you can see the Cook Islands to the right here, exclusive economic zone, surrounded in red. So we're south of the Hawaiian Islands. Our island, the main island of Rarotonga, is about the same distance south of the equator as Oahu, and Hawaii is north of the equator. So these are the 15 islands of the Cook Islands. The main island of Rarotonga is down the south here. And you can look at the scale, you can see that we have about 1,400 kilometres on the scale. So you have islands that are very spread apart, tens to hundreds to thousands of kilometres apart. And our ecosystems are, coral reefs around, fringing reefs around the islands, and then we're separated largely by deep ocean, and it extends to a depth of about 6,000 metres or 6 kilometres. So a very deep ocean ecosystem that's the main ecosystem that we have in our country. So we really are a large ocean state, and we're about the size of Mexico, so it's a big ocean state. Our main industries are tourism, fisheries and manufacturing, clothes manufacturing, fisheries, jewellery production. These are black pearls. We farm black-lipped pearl oysters. Our population is very tiny. We have 18,000 people over these 15 islands. 12 islands are inhabited, 3 are uninhabited. We are self-governing with a Westminster-style parliamentary system. So this is our Prime Minister, Henry Puna, and he has a very different perspective on nature, and he attributes that to coming from Manihiki, which is one of the islands in the far north. It's an atoll, and he said in this magazine a few years ago that he wanted to see people to view the ocean as not an open space with pockets of protected areas, but actually a protected space where we look for areas for commercial activity. So this perspective led to the announcement of Marae Moana. The actual idea of Marae Moana came from a celebrity in the Cook Islands by the name of Kevin Iro. He's a rugby league star. He was a Kiwi, represented New Zealand, and has also played for clubs in England. And he came up with the idea of establishing Marae Moana and approached the government, and they loved this idea. So it was announced in 2012 at the Pacific Island Leaders Forum as being the largest area in history by a single country for integrated ocean conservation and management. So the consultation process was very comprehensive. There were 5 years of consultation beginning from 2011. We actually started back in 2010, but the real consultation process happened over those 5 years. So many village meetings, workshops, committees and task force to develop the policy and the legislation. So it was a very inclusive process for developing the policy and legislation. So we were really concerned that the policy should be responsive to what the people wanted. So the original proposal was that we were just going to be protecting the southern half of the Cook Islands, and it would be a multiple use, possibly or conserved. It wasn't really set in stone. It was just a proposal. So when we took this map round to all of the islands, the people said, you should include the north. The north needs to have some protection as well. We like the idea of making it multiple use, but we want to have large protected areas around each of the islands. So this is what was resulted as the current law establishes protected areas that extend 50 nautical miles from each island, where there's a higher degree of protection and the law establishes a protected area around the whole exclusive economic zone, which is for multiple use. So that needs further management. Inside these protected areas are where there's no large-scale commercial fishing and seabed minerals activities allowed. So that they make up about 300,000 square kilometres. So the two documents that are guiding us are the Marae Moana Policy and the Marae Moana Act. And we're developing further regulations and policies as we go along. The principles are in both the policy and the Act. So these principles must be applied when making decisions about our ocean and developing legislation and policy with respect to our ocean. So the policy also includes in its scope that land activities must also be managed. So it recognises the connectivity between the terrestrial and marine environment and supports the management of activities on land which may adversely impact the marine environment. So you can see our islands are very tiny. This is Rarotonga, the main island, and it has a circumference of about 32 kilometres. So every activity we do on land affects our marine environment. So all terrestrial activity has an impact. So therefore, it's marine conservation for us is also land conservation. So establishing terrestrial protected areas are just as important. Managing land activities on our islands is just as important as having marine protected areas around our islands. And so the policy and the IUCN guidelines for protected area legislation were also used to guide the drafting of the legislation. We depended on those very much in the drafting of the legislation. So we had a professor from the University of the South Pacific, Justin Rose, he was previously a professor there, who drafted our legislation. And the legislation establishes the Act over the entire marine space, establishes the Marae Moana over an entire marine space, including the lagoons and reefs. So all of the principles and policies apply to all of these different ecosystems in our marine space. It also sets up the institutional arrangements and provides for marine spatial planning and zoning throughout the exclusive economic zone as well as at the island level. So you can see that we have to have two types of marine spatial planning. One is the very deep ocean, large scale marine spatial planning that we're about to embark on. And the other is the smaller scale marine spatial planning around the very small atolls at the local scale. So we're working with two scales when it comes to marine spatial planning. And again, it establishes marine protected areas around each island where there are no large-scale commercial fishing or seabed minerals activities permitted. And that's based on the IUCN guidelines where, you know, you need to have this marine protected areas established in the principal legislation in order for them to stick. And it requires annual reporting and monitoring and evaluation. It has a lot of provisions in there about reporting and evaluating the work that we're doing. So in terms of the rights of the Marae Moana Ocean, the hierarchical objectives of the legislation enable us to protect the ecological biodiversity and heritage values of the marine environment as the primary objective. And then there are other purposes of the legislation which are integrated decision making, allowing other uses, including economic use, which must be consistent with the primary purpose, and encourages engagement with stakeholders and assists us to meet our international responsibilities, the conventions that we're signatory to. So, so it's important that the economic activities must be consistent with the primary purpose. So this applies across the entire EEZ, the entire ocean territory. So we're right now working out the details of how this this objective is going to be applied in terms of economic activities. So still a lot of work to do yet. So this is just a list of who is in the Marae Moana Council. So it's a very high level council because it has the Prime Minister as well as the Leader of the Opposition in the council. We also have the representatives from different sectors of our society, an NGO representative and a private sector representative, traditional leaders, that's the House of Ariki, the high chiefs of the Cook Islands. And then they are advised by a technical advisory group. So this advisory group is comprised of the Office of the Prime Minister as the coordinating office, and then includes the regulatory bodies that regulate marine activities in Marae Moana. And then we have our traditional leaders, the House of Ariki or the Kutanui. The Kutanui is the lower house of chiefs, and 2 NGO representatives. So just to touch back on what we meant by ocean kinship, Prime Minister Puna at the UN Oceans Conference in June 2017 said that we are the ocean and the ocean is us. It is in our DNA and gives us life in the same way that a child respects and depends on its mother for life, nurturing and sustenance. So that's what we mean by ocean kinship, is that worldview of, we are part of this whole system. And this is what led him to state at the same conference, but at a different event, that, we have a deep respect and regard for nature, and realizing that it provides for our needs and the needs of generations to come. And therefore, Prime Minister Puna asked that we explore the concept of the rights of the ocean as a legal person. So that's really how we I guess, pitched the rights of the ocean to the world, coming from the perspective of a person who was, a pearl farmer before he was a politician, and lived in an atoll right by the ocean. I guess that's really the motivation behind establishing Marae Moana for him. So that's all I've got to share. So hopefully, I think we've got a bit of time. I'll hand it over to you, Michelle.
Thank you so much, Jackie. That was great. We are having a few questions already popping up on the chat that I can read. And then as we're going about to, feel free to unmute yourself and ask a question as well. You don't have to type it. One question that was asked was, I'll go back to the beginning so I don't skip. How would recognition of rights in nature help combat ocean and plastic pollution? And I just noted that I've been exploring that and have given a little presentation and blog on it before, but I think, for me, it's about requiring this holistic outlook when we're going about not only drafting laws, but also implementing the ones we have. And I think a great example of that is the Clean Water Act here in the United States, where, at a national level, we don't actually require plastic pollution to be addressed through the Clean Water Act, even though it is considered a pollutant. But some states are moving towards implementing their own measures, such as finer mesh screens over storm water, drains, and things like that. And I think one of the biggest things, like if rights of nature were to be recognized, or, we were striving towards this more holistic law that recognized the land-sea connection, we would then need to be placing standards on the amount of plastic pollution we do allow into our waterways. And so we would have to implement measures like the finer mesh screens, or not allowing industries to discharge them in the first place into our waterways is a big reason. And I noted that I can share that to Macy, but I can also share that with others if we're interested. There was another question about working with other organizations like SailDef on rights of nature, and there is a global network called the Global Alliance for the Rights of Nature. Over 100 organizations and individuals are part of that right now. We're also working on developing regional hubs for that, so that we have, a South American hub working together on the movement, North American, African, and so if you're interested in that, we can also provide more information towards the GARN website and membership as well. And one question from Jeff is, as a lawyer, I get worried by phrases like appropriate balance. So I think this is in regard to maybe Jackie's hierarchical objectives. When the environment is mixed with the human economy, there is a long history that balance being struck more in favor of the economy than the environment. Indeed, the SDGs strike that balance in that way. Unfortunately, see SDG 8. How do we get past that with rights of nature? Are rights of nature too embedded in the anthropocentric paradigm to succeed? If not, isn't that the anthropocentric paradigm the heart of the problem, such that rights of nature cannot succeed until we get to a human inclusive ecocentric paradigm? So it was a little long, so if other people can read that on the chat. Maybe I would just offer my agreement with that statement, actually, because, for example, I actually look at SDG 14 and see that the objective is to conserve and sustainably use the oceans, but it's for sustainable development. It's not to conserve and sustainably use the ocean for overall ocean health or earth functioning, anything like that. So even that still has a very anthropocentric point of view and language that we use in it. So I would agree that it is really about a paradigm shift, and it's about getting, acknowledging that our current worldview and values underlying our governance frameworks really need an uprooting. But maybe I'll see what Jackie and Barbara or anyone else might have to say about that.
Michelle, maybe I could just throw some thoughts out on the plastic question. Yes, it's everywhere now. It's in the land, it's in the air. Plastics get deteriorate into microplastics. Here at Moat, we have a lot of examples where marine mammals, especially, and sea turtles, will, we're on the Gulf side of Florida, will be carried ashore with the waves, and then we have to do the autopsy. And inside the stomachs are frequently now just big wads of plastic, where the dolphin or the sea turtle thought that was food. And I think a big part of this plastics movement, there's now there's a listserv group being managed out of the MPA folks in the University of Washington, just on marine debris. And I'm on it, and I get a few emails every day. A lot seems to be happening locally. The issue is education, especially because we have now citizen movements that are going to the restaurants and saying, no more straws, no more styrofoam, whatever. Now, it's not a law. Florida is one of the worst states in terms of banning plastics. They just passed a law saying local jurisdictions cannot ban straws. So it's just, but the community itself is very concerned. And the more we see these pictures, the more stark is the reality that the ocean environment is truly the victim here. And so we just have to keep working on all of this.
Yeah, I think I can add that the other thing is that the pressures to get resources, you know, so for example in the Cook Islands we have this threat of seabed mining because our deep ocean has manganese nodules, which, you know, these tiny well, potato-sized shaped rocks that were sitting on the bottom of the seabed, which contain a lot of rare earth elements and manganese and cobalt. So there's pressure to extract these nodules because you know, the cobalt is in demand from the growth of the use of renewable energy. So electric cars and, you know, batteries and so on that depend on cobalt is causing this pressure to extract these nodules from our ocean. So you know, while we can educate, you know, it's the pressure that this world is demanding. There was a question there in the chat about water. You know, how do we supply more water to California? Can we use desalination? You know, so it seems like our growing population and our demands for a very high quality of life are also part of the problem. So, you know, I don't know how much we can go back to just living simply and trying to educate people to live simply and make do with what you have, which goes for us in the Cook Islands as well. We're doing pretty well economically. We don't actually need to harvest these minerals. It would just mean that we would live a very comfortable life. But that's my comment. I don't really have any answers.
Well, Jackie, I'm actually really curious too when it comes to the seabed mining issue in Cook Islands, is how has that been progressing with the Marae Moana policy about, you know, showing and having the burden proof on that company or whoever wants to do it, in showing that it's not going to have an effect on conservation. Where is that at there?
We do. Well, we've been approached last year. You know, soon after the legislation was passed in August 2017, the Marae Moana Act, and not too long afterwards, we started being approached. Not myself, not my division, but another agency was being approached by companies to look into exploring our ocean for manganese nodules. And I know that the Seabed Minerals Commissioner, who has been an environmentalist, you know, in his previous life, I think he still is at heart, but he's now got the job of, you know, being a Seabed Minerals Commissioner, making sure that any mining is regulated appropriately. He stated, "Oh, thank God for the Marae Moana Act." So, you know, we could see that it did actually make a difference, but we've still got a long way to go because, you know, we've just recently, just last week, passed a revision of the Seabed Minerals Act, and we were able to ensure that there was greater consultation than had been originally planned, so that we had a lot more feedback from the community on the Seabed Minerals Bill that was drafted. But, you know, we still have a long way to go in terms of educating people about integrated management, about making sure that plans and, you know, initiatives are sort of kept together with the group, you know, and people are not going off on tangents, working independently. So we still have behavior that we have to change. That's happening within our government system, and we've got to manage that and educate people and keep talking as we go forward.
Michelle?
Mm-hmm.
Yeah, I just wanted to explain a little my,
Oh,
I
yeah,
guess
go
respond
ahead.
a little, add to what I said before. And I think on this question of paradigm shifts, I think ultimately I would like to, the thought experiment I'm doing with myself is rights of nature are often cast as giving nature personhood because legal personhood is something that exists in the law. My concern is that's sort of fitting rights into a very anthropocentric framework. So my long-term vision, the thought experiment I'm having, and I invite others to have within these ongoing discussions, is what if we thought of rights of nature as giving naturehood to people? And I don't mean that just as a play on words, but as something, an idea that you have to develop, because I think it really does get to that paradigmatic question. It forces us to do things like insist upon responsibilities along with rights, as you mentioned, that when we talk about ecosystem services to people, we actually also in the same breath have to talk about human services to ecosystems. Because otherwise we're only getting part of this story. It means we have to, for example, look at responding to human demand for things on the basis of reasonable needs, especially with things that come from mining, rather than from wants, and often luxurious wants that are driven by the market and not by an eco-limits sensitive set of norms and systems. So I just want to offer that idea of giving naturehood to people is kind of an envelope in which we can really come up with some new innovations in this area.
That's a great idea. Thank you. And I just noted that Katie put an article that someone wrote about that idea in the chat box, and we can make sure we pull that out too so that it's available for everyone. Yeah, and I think that's, one of the challenges that we're still finding is that, and how I mentioned just a little bit too, that it's really about getting to our responsibilities. And I think that naturehood idea can come into play because there's also this great graphic that really shows what we're trying to do with the paradigm shift that doesn't even mention rights of nature, but it shows how right now our economic system is the largest, and then human systems, and then natural systems. And that's how largely the Western worldview is. But in contrast, in how we actually know these systems function in practice, is natural systems is the largest and controls all others, and then human systems, and then economic systems below that. There's a great graphic showing that we can pass around too. And I think that's really what we're trying to do with the paradigm shift. And rights of nature is just one way we can start to have that conversation and start to, the education behind, how we got to where we are now and what sort of changes we need to do. But there's certainly a lot more than just rights of nature, certainly.
Michelle, can I step in?
Of course.
Jeff, your comment is so interesting. So perhaps some of you will remember in the 80s, a lot of stuff was being written about the rights of nature. And we had, I think Christopher Stone out of University of California wrote, "Do Trees Have Standing?" And that was an effort, he was a lawyer, to try and get people to think about legal systems and judicial tradition and norms in a way where the rights of nature, whatever we wanted to call it, had some legal standing, because otherwise we would be destroying, we would be making more chaos if we didn't have the legal system. So, I mean, that's how some of this started. And in the 80s, then there was a lot of writing about the use of an ombudsman. And again, authors were using words that people already sort of were familiar with. An ombudsman for community rights in context of a mining project or whatever, or the ombudsman for a person who's an employee and they can't defend themselves, and so they go to an ombudsman. And now we use guardian. The ombudsman is sort of the person with the nature responsibility. If we worked with your idea, Jeff, and tried to broaden it a little bit, I think one of the reasons it's a challenge is because, just like Michelle said, in visionary terms, economists and the private sector could say, oh my goodness, this is going to create chaos and economic collapse. Just like some industries and politicians still say there's no climate change because it would create chaos and economic collapse if we tried to really seriously deal with it. So this has got to be a long conversation. You know, the 80s is 30 years ago, and now we're working on this because we know so much more scientifically about the connection and the dependency of human life on nature, and that we know that some human decisions can work against nature, i.e. against human life. So just thoughts I throw out.
Great, Barbara. Any other thoughts to Jeff's question and comments? And this can be for anyone, really open discussion. Okay.
Michelle,
And
maybe you could explain at some point after the comments the UN resolution on harmony with nature.
yeah, and I know Maria Mercedes was on one of the previous webinars with this series and talked a little bit about the initiative as well, and we can make sure that people are able, the YouTube video is up on the website, so we'll have access to that. And I also want to, just before I forget, a lot of people have been asking, is this recorded? Yes, it's recorded and it will be available after as well for you to share and everything. And I can speak more to the Harmony with Nature initiative in a little bit, but I noticed we have a few other questions that came through the chat box. We could mention them pretty fast. Let me see. So Nicole mentioned applying this framework to more than just marine plastics. Yes. Can we discuss more broadly the things that we are hoping to protect the environment from? Sorry, every time a new comment comes in, it just switches on me. And for whom are questions of equity raised? Who stands to benefit from this approach and who stands to lose out? I guess I would just start with that ending question. Who stands to benefit from this approach? Who stands to lose out? I think we all stand to benefit. And it just comes back to that, you know, education and awareness component that, you know, without a healthy environment, we would not be here. And without a healthy environment, we can't realize our own human rights. So even though it may seem like some, you know, rights and nature laws are against an industry or, you know, a specific activity, as is some of the case with some of the laws here in the US actually, but I think it just really comes down to the realization that it's for the rights of future generations, and it's very, you know, long-term motivated, so that, you know, if we don't do something now, if we don't at least limit or regulate our activities to a degree to where they can provide this balance with nature, then, you know, we're not going to be able to continue to fish. We're not going to be able to continue to do, you know, some of these activities into the future because we would have destroyed the environment. And I don't know if anyone else has some thoughts on that comment in question. Let's see, I think we have a few more up here. Feel like I'm missing some as I scroll through. Are there ways to, this question is from Gray, more comments coming in. Are there ways to, let's see, figure out a better way to keep it on this same question I'm trying to read. To including conceptions of restoration to historic baselines as part of the conception of what the ocean has rights to, or perhaps shifting to a notion of enhancement independent of past baselines. Why merely sustain when we can enhance? Barbara, have you been coming across any of this sort of work with historical baselines? Oh, you're on mute.
I really followed this first ever census of marine life. And that, for purposes of marine life, is our current baseline. It's our historical baseline, because we haven't had this kind of global census before. And I do think, you know, the researchers that were part of that and other researchers, because now it's open to everybody, you know, there's a database of biodiversity, et cetera, ecosystems. And I think from what I understand, because I've talked to some of the folks that were part of that, they really are viewing this as the baseline for research going forward. It's not the first baseline. I mean, look, we've had 2,000 years of, or more, of people working the ocean. But it's the one they consider to be scientifically defendable at this point. And I know researchers, especially with climate change and sea level rise, they will be looking for change in species as you know, the canary in the coal mine, that kind of thing. But otherwise, there's so much we don't know about the deep ocean. It's very hard to operate these machines deep down, and with humans, only so far. The deepest you can't go with humans because the pressure's too hard. So, but technology is moving.
And I see, Gray, you have another comment to that?
Yeah, can I just follow up? By the way, thank you so much for this whole presentation. It's wonderful. I think that for at least some regions of the world, people have been doing historical research to try and find out historical baselines that go back into the 1800s or earlier. In the Gulf of Maine, for example, that's happened. And it's really quite significant, the extent to which there's this process of shifting baselines where, you know, people think, oh, gee, the fisheries are getting diminished, but where they're thinking about what it was like when they were a kid, a generation ago. But if you go back 2 or 3 generations, you find dramatic differences in what's been lost. And I think if we sort of take the current state of the ocean as our baseline that we're trying to sustain, we're really doing the ocean and ourselves a significant disservice, because we've already deteriorated coral reefs, fisheries, whale populations. We've created an enormous amount of toxicity in the whole system. And so I think that rather than just talking about sustaining what we have, it's worth asking whether or not it would be appropriate to be thinking about trying to enhance what we have. And
I completely agree.
one strategy for that may be to try and use historical techniques to reconstruct baselines from the past. But another strategy would be to say, why use the notion of sustainability as a constriction? Why not look for opportunities to enhance independently of what the baseline was? Just as a farmer might think about, not what was my best crop so far, but what would be good crops and a good system, an enhanced use of this land. Thanks for the opportunity to share that.
Gary, I agree. This is Barbara. I mean, sea level rise is changing this so much along the coast already, but I haven't had a chance to dig into the new efforts to measure ocean health, the Ocean Health Index. That I believe it's an effort coming out of the University of California, maybe in Stanford. And if you look at what's there now, unless it's really pristine, I agree with you. This word sustainable or sustain is really complicated in a legal framework. And you're right. We are so far removed in many parts of the populated world from what we would hope to achieve in restoration. We're still going to lose so many species if we just sustain. So I agree with you completely.
Yeah, and I would add on to that, it's that idea of health is that we're still aiming for health or healthy based on, you know, a very anthropocentric or, you know, baseline that doesn't go as far back as it should. So what we think is healthy really isn't. So we also need to change our understanding of what the ocean needs to be healthy and what it needs to thrive. And I think there's a lot of work that needs to be done on that, because even with, you know, the great work that's coming out from the Ocean Health Index, it's still, you know, right front and center that it says a healthy ocean provides benefits to humans now and into the future. And I think that's a very lopsided way of looking at what a healthy ocean is. So we definitely need a lot of work on that. And I want to note that we're a little bit past an hour and a half. So I want to maybe just see if any other lingering questions or comments from anyone. And then obviously we will have our contact information, follow-up information for everyone who signed up or registered for the event. But just to see if there's anything lingering that we weren't able to get through the chat box. Anyone has any last questions or comments? Think not.
I just, maybe just to note on behalf of the entire series that so that people know that this has been recorded and will be posted on various sites. And be sure to check the rest of the schedule, because we have monthly, at least, webinars coming up through December.
Yeah, the next one will be, I think it's June 28th on principles and policies that inform ecological law and governance. So kind of the history of ELGA, from my understanding. And then that the website is also taking suggestions for future webinars in 2020 as well. All right. Well, thank you. I know we lost quite a few people already, but just wanted to say thank you for attending and the great questions and discussions. I really look forward to following up with everyone. Thank you, Katie, Jeff, for helping out with this. And of course, Barbara and Jackie, thank you so much for your expertise and your presentations. I love learning more about the great work you both are doing.
And thank you, Michelle.
Thank you, Michelle. Thank you, everyone. Thank you.
Oh.
All right, take care.
Take care, everyone.
Okay, thanks. Bye.
Thank you very much. Bye.